Well, hello there and welcome. We're back with another edition of the Disability Law Show. Good to have you tucked in for the half hour, so stick with us. You will learn a lot. That much I can guarantee of the world of disability law and how to deal with those insurance companies as well. John Scholes here, Tamar Agopian right there, disability lawyer at disabilitylawyer.ca, disabilityrights.ca. You want to go online to contact Tamar. Phone number is always good, right off the top, 1-855-821-5900, help at disabilityrights.ca. Lots to cover over the course of the half hour. We'll get to some emails, possibly some phone calls from one of our radio shows, and we always have a main topic. This week, it's going to be what to remember about long-term disability and CPP, Canada Pension Plan Disability, how they work together. Tomorrow, we'll get to that in due time, my friend, but we always start off with a week that was or a case of the day. What's going on?
Busy weeks, lots of busy weeks, and a lot of the time spent on trying to focus on how do we resolve these claims for our clients. And we've shared this on the show before, but I think it bears mentioning that a lot of the time when we get involved in our claims for our clients, we really focus on trying to get the insurers to a point where we can essentially have a reasonable discussion around settling the claim. And so the hesitation for many people when they contact us is, look, I don't want years and years of litigation. You know, I don't want to get inside of a courtroom. What's a judge going to say about my claim? And the main thing that I think I want our viewers to take away is that the vast majority of these claims don't see the inside of a courtroom. And across the country, there are mechanisms, one in particular that I want to chat about called mediation. It's a very effective tool in resolving these claims quickly, efficiently, and quite successfully. And so when I think about success stories and what I wanted to focus on today at the top of our show, it brings to mind a couple of mediations I've had, a series of them, that dealt with people who had multiple claims with the insurance company, who had tried to move the needle with the insurance company themselves, and then eventually got to a point where they had to come to us, retain us, and get us involved. And we were able to short circuit a lot of the issues that were raised against our clients to the point of actually successfully resolving the claim at a mediation. So for those who don't know what a mediation is a non-binding settlement meeting. You know, these processes do not involve a judge or a court, as I said before, and they are privileged and they're confidential. And the idea of it really is that it allows the two sides of a piece of litigation, like our disability claims, to get into a virtual room these days. So it's not even in a boardroom or you don't even have to leave the comfort of your own home for most of my clients. And we get to directly speak to the insurance company to explain to them, this is why you got it wrong. This is your exposure, these are your risks, and this is where we see this going if it were to see the inside of a courtroom, and how a judge might view this, perhaps even a jury. And look, we know that most of these cases have been found in favor of claimants anyway in the last 5 to 10 years. And so we're looking at it in a very good position on behalf of our clients. And so in particular, John, I was dealing with a client who, and I want to keep his confidentiality, but I was dealing with a client who had had 4 disability claims with the same insurer in a matter of a decade, resulting primarily from relapsing and remitting major depressive disorder. And so, look, depression tends to have this kind of patterning for some people where they commit to treatment, they try and improve, and then, you know, in the end, they're not capable of returning to work. And in my client's situation, he was able to go back to work in periods after being off for about 8 to 10 months. But this last claim, he had been off for several years, in fact. The insurance company had actually approved his claim, had agreed that he was not capable of returning, not only to his own job or his occupation, but in any other work setting as well, because his depression and other health issues that he had made it so disabling that he wasn't capable of functioning in the areas that he had training and experience, and that would pay him a wage that made sense even in the alternative occupation phase. What's really interesting about his claim is that the insurance company had him assessed by the same doctor 3 times. The same expert, the same psychiatrist confirmed all of the things that my client's doctors had already said, which was, this is disabling, these conditions are effectively permanent for him. We have tried every medication under the sun, and we're still not capable of improving him well enough to do sustainable function, sustainable work. So in other words, something past even 8, 10 months of work. But the insurance company, of course, as in their wisdom as they do, they were getting impatient. He was relatively young, hadn't quite hit 50 yet, and you could see that there was a long, at least the insurance company could see that there was a long trajectory here of potentially 15 years of further LTD benefits that were payable to him. So they forced him into some return to work plan. They had someone who wasn't even qualified, an occupational therapist, do assessments, and based on those assessments ended up cutting him off. But they hadn't consulted with his own doctors, and they had ignored their own doctor about the ability of my client to be able to return back to work. And so, John, these were the makings of an excellent legal claim. We got a fantastic result. And the mediation setting was very comforting for my client because we prepare, we do all the legwork, we got all the medical information. I prepare a fairly detailed brief. I put all this information together. I outline all those risks. I talk to insurance companies about damages and other areas of compensation that my client was entitled to. And in the end, surprise, surprise, but not surprising, they came to the table. And we were able to settle the claim. And we were able to settle it in a way where we were able to get a buyout for my client for a long period of time that would have been payable for him. And why that was really favorable for him in particular was because he actually didn't want to deal with the insurance company time and time again. He'd already been through 3-4 claims as it was, and this was an excellent outcome for him that we were able to achieve, as I said, in the mediation setting. So for those who are viewing and wondering and concerned about what it looks like to retain us, we try and make it as easy as possible and really can show those results to our clients within a fairly efficient period of time without having to have a judge weigh into the situation.
Is that the whole point, is to avoid going all the way to court? Nip in the bud with mediation generally? And how do most clients think, well, why can't I go to court and settle this? And then they realize maybe this is a better step. Yeah?
Well, look, it's always a case by case.
Right.
I never want to suggest to anyone that it's a one size fits all, but it certainly is a recipe for success. And so we have those conversations with our client. And quite frankly, John, we are one of the few teams that have extensive trial experience as well, which I can assure you many of the lawyers that the insurance companies retain don't have that experience, and many other firms don't have that experience either, because it's so rare for these cases to go all the way through to a trial anyway. And so we look at those risks. If the insurance company is within that ballpark that makes sense, given those risks, then why wait 3, 4, 5 years to see the inside of a courtroom with a judge who may or may not agree? And so in my client's situation, it absolutely was the right approach. But if a client said to me, look, let's go all the way to the trial, I'm happy to do it. I just think that we need to think about alternative ways to resolve these claims for our clients that don't involve them having to deal with the insurance company, say, through their appeal process, but also potentially not be so risky that they're destitute by the time it gets to a trial, or they get an unfavorable result in a trial setting.
And intimidating being in court, then nobody wants to be there. Right?
Absolutely, and it's a lengthy process, very exhausting, and it's not only just the claimant. Usually you need to build that case with other family members and their medical team, and so again, it can be a very long and drawn-out process when there's these alternatives like mediation that's an extremely efficient way and really effective to getting those results for our clients.
I heard, now I could be wrong because I've never been wrong, is it not kind of in some jurisdictions like Ontario, maybe possibly Ottawa, Windsor, I think, maybe mediations are mandatory?
They
Which
are.
is a good thing, right? Did I get it right?
You did get it right, John. You did get it right. And so, look, absolutely there are jurisdictions, certainly in Ontario and other areas of the country, where this mediation process is mandatory.
Good.
And it's been good because it's been a forced adoption by parties like big corporations, employers included, insurance companies included, to have to sit down and talk about the claim reasonably. And so it dissuades the idea of long, drawn-out lawsuits and claims and really having the only answer, the only recourse being getting in front of a judge. And so this has been a really good, positive development, certainly for claimants like our clients, to access justice and to access it early and in a way where they're going to get a really fair shake and do so really efficiently in a cost-effective way.
Online tool we call it Pocket Disability Lawyer, pocketdisabilitylawyer.ca. What do you think about it?
I really like this tool. This really dovetails nicely with the way that we want to push out as much free information to people as we can. It has a drop down. You can put in some simple information and find out what your legal rights are. And if you don't want to contact us and speak to a lawyer and have a free consultation, that's okay. You can pop out of your browser. It's completely anonymous. But at least it's a starting point where you can figure out, okay, do I have a claim here? What does that look like? And should I actually be speaking to a lawyer in that context? Excellent tool.
Again, pocketdisabilitylawyer.ca to get a hold of that. Phone calls, where do we get them? Well, we do radio shows across the country. Tamar and myself and Savannah, James, we're all over it. And a lot of people do us the benefit of calling into the show, asking questions. We take some of them, we play them back here, and we can always learn from them. Tamar, first phone call from one of our radio shows is coming up right now. Listen up.
I have a friend who had knee surgery, and she's on short term. She's got 15 weeks of short term, and the doctors basically said, you know, you have to be off. But the insurance company and the employer pressuring her to go back to work before that. I'm wondering if normal and if the insurance company is really the one to assess if she can go back to work or not.
I really adore this call because, no, it's not normal, but does it happen? It absolutely happens, right? It happens so routinely that we really term this as a tactic that insurance companies use to inject themselves into your, treatment plan and suggest to someone that you're good enough to return back to work. And so, look, I appreciate friends calling on behalf of friends in situations like this. And I think, quite frankly, I would like to speak to the person who's experiencing this so that we can actually have first-hand conversation with these claimants. Our consultations are absolutely free. Don't hesitate to contact us. But just to be more to the point, what our caller tells us is that his friend is transitioning, is at least in the short-term disability phase, is 15 weeks, has doctors supporting, and then you've got an insurance company who's saying, you know what, we think you're good enough to return. And so let me unpack this. I suspect it's because the friend is transitioning from short-term to long-term. And if that's the case, you're going to get the long-term disability insurer who might actually be the one administering the short-term claim, saying, we don't want this person on claim. They've got a significant knee issue. They may or may not recover. If we resist the transition from short-term to long-term, then we may not have to deal with a claim at all. And that's why there's these tactics happening with the push towards returning back to work. So, John, when people call us in situations like this, my first advice is always make sure that your own medical team is engaged in the process. You want to make sure that your own doctors have written or put something in writing or sent clinical notes to the insurance company to say, still on a process of recovery, I have not cleared my patient to return back to work. Here's why. Because it's that much harder to ignore in a situation like that if the insurance company is going to do what they always do. And that really is the best way to push back to an insurance company when they're trying to pressure you back to work. And you want some guidance on whether or not you can return back to work anyway. This is a medical question, folks. It's not a legal one as to whether or not you should be working. And the insurance company doesn't get to dictate that. Yes, there are consequences. Yes, you may be without your disability benefit for a period of time. But if you've got your doctor saying to you, you shouldn't be working, then in my mind, full stop, not only should you be entitled for disability benefits, but you also want to preserve your own health and follow that advice despite what the insurance company is trying to do, which is, as I said, injecting themselves into your treatment plan and trying to push you back to work for their own means, their own goals, as opposed to what's in the best interest of the claimant.
If this insurance company hasn't already on the cusp of the transition, will they likely that they'll send this person for an IME, an independent medical evaluation? Could they do that?
They could. Right. They could. And so this goes back.
And you got to go, right?
Well,
which is fine, but.
So look, there are sections in these disability policies that say, if we think you need X or Y, if we think you need to be assessed or reviewed, then we will arrange that and we want you to go ahead and do that. And so could it happen in a situation like this? It could. Should it happen, though? Probably not.
Right.
And I think that's really the key question, is that if there's enough medical information to support the disability claim, then there should be no reason for assessments to be happening. The only reason I could see that is to shore up for the insurance company their basis to cut off the claim improperly.
We'll take a short break now that we're through the first part. The main topic is always in the second. That's how we'll start off. And what you need to remember about long-term disability and CPP disability, how they work together, that is on the way. Lots more Disability Law Show is just ahead. Stay with us.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
And welcome back to the Disability Law Show. Tamar is always available at disabilityrights.ca, help at disabilityrights.ca to send along an email. And those consultations are free. So is the chat. Just call 1-855-821-5900 anytime we're not doing the show here for the half hour. Okay, what to remember about LTD and CPP disability, how they work together. I guess before I ask you my first question, Tamar, we know what LTD is. How about just a 10-second revision or a reminder what CPP disability is as well, right?
Canada Pension Plan Disability Benefits. That's what it stands for. And gosh, we use these acronyms so freely, but fair point, John. What it is that it's a government-sponsored disability benefit. It's monthly. It's available to individuals who have a severe and prolonged disability. It's a two-part test, separate application. You make it to Service Canada, and you wait to see whether or not you're approved.
All right, so first question, many disability policies, as we've talked about forever on the show and the radio show as well, have a provision about CPP disability deductions. How does that work?
Good question. And so how does it work? Look, no two policies are the same, but I can assure you that every policy that I've seen has this deduction in it, okay? And so what do I mean by this? Is that it is actually very important to always have a copy of your disability policy. Even if it's gobbledygook, you can send it to one of us. We will find the right spot of the 40-page, sometimes 100-page document, and we will share with you what the details, what the words actually say. And invariably, these policies have similar headings or subheadings, and one of them will say, we will pay you X, except if you have entitlements or eligibility to other sources of income. And these insurance companies, they're not dumb. They have good lawyers who are writing these policies, and they know that if you are entitled to disability benefits from the same disability, they want to get credit for that, okay? And that's what these policies say, is that we will pay you X, but if you have an eligibility or an entitlement to other sources like CPP disability, we're going to take a deduction from
100%.
that.
Makes sense, right?
And it does make sense, but here's where they vary, John. Some policies will say this is a direct offset. Some will say it's an indirect offset. Some will say we get the family benefit as well. So if you've got children, they also get approved for a benefit, all sorts of things. Bottom line is, if the insurance company can get a credit, they're going to take the credit. And you want to be sure that they're taking the right credit, because they only get the initial amount that you receive as your disability. So let's say in a world in which you apply and government approves you 6 months from now, and they approve you all the way back to a year or two into the past.
Okay.
Well, then you're going to get a retroactive payment, and that retroactivity will go back to potentially 2024, 2023, depending on where you're at. The insurance company only gets your initial amount because the government will actually increase that benefit year over year. Insurance company doesn't get that increase. They only get the initial award as their credit.
Going forward.
Going forward. So again, the words matter, the details matter, and so what I always say to people is not only do you want to get your policy, but if you are approved for this benefit, make sure that the insurance company writes to you, tells you how they're doing the math, make sure they've done the right calculation, and if you're not sure, give us a call.
It's all in the gobbledygook. That's a legal term, by the way, gobbledygook. Number 2, being approved for CPP disability can definitely strengthen your LTD case. A lot of people are gun shy about it, but it's actually a good thing, right?
It is.
What you just said.
I think the pros far outweigh the cons. And so, yes, does it mean you're getting less money from the insurance company directly? Absolutely. But at the end of the day, you're now approved by the government to have, remember, a severe and prolonged disability. The test, folks, for disability for long-term policies is usually, are you totally disabled, either from doing your own occupation or any occupation? And those terms, total disability, I can assure you, are not interpreted in the same way as CPP, which has words like severe and prolonged. So if I've got someone coming to me saying, insurance company has cut off my long-term, but I'm CPP approved, I'm saying to them, this is a no-brainer. This is excellent leverage against the insurance company to say, hey, the government has approved them. Their doctors have supported the application. So now you've got even more medical support to leverage against the insurance company. And the insurance company ends up being the outlier. And so we say to them, so government approves, doctors are supportive, and you guys are the ones saying that this person isn't totally disabled? This doesn't jive. Yeah. So absolutely, the application for CPP disability in and of itself is helpful in terms of our claims and our disputes against insurance companies.
Right. Final point is this: refusing to apply could result in reduced LTD payments or even suspension of benefits. You kind of got to do it. Right?
This one really bugs me because this is really the fine print. There are some policies that say, even if you don't apply, we get to take an estimate against what it is that we're paying you. So insurance companies use that kind of language to say, it must therefore mean that you must apply. And there's one insurance company who routinely will send letters out to claimants saying, your policy requires you to apply for CPP disability. If you do not apply, we consider this a compliance issue, or we're taking the credit anyway. It's not actually the case. But don't forget what we said in points 1 and 2, which is if you've got an entitlement to it, you best apply anyway. But if you've got a really aggressive insurance company who's saying, we're taking this estimate against you in any event, or we're considering it non-compliant that you did not actually apply, then please do give us a call because that's not quite right. But at the end of the day, I still think the application makes the most sense because why give the insurance company any opportunity to take an estimate against something that you're not actually getting? Because let's play this out, John. What if you do apply and you don't get approved?
Right.
And many people don't necessarily get approved the first time around. This is an area where
it's severe and prolonged.
It's severe and prolonged. Right. You need time to go by. You may need more medical support. And quite frankly, you may have a government agency that's not doing the same, reviews and this kind of thing. And so, nope, denied. And then maybe you want to consider an appeal and what have you, which, by the way, we can assist with as well. But more to the point is that in and of itself shouldn't be what's holding people back. And should also not be the excuse by the insurance companies to say, now you're not entitled because either you've been denied or you haven't even applied.
Right. So 2 quick points before I know we got a break. Number 1, if you do apply and you get approved, it's an offset. So if you're getting $2,000 from LTD and $1,000 from CPP, you don't get $3,000. They take the $1,000, so you're still at $2,000, right? So it's even.
Absolutely.
Secondly, the good thing you always say is in the case that you do get cut off from LTD, if you've got CPP coming in, you've still got some income.
That is the best point ever, because I think that's the biggest takeaway is that they are independent. So in a world in which you do have long-term taking a very aggressive position and potentially cutting you off, you can rely on your CPP benefit for a period of time to give a lawyer like us, our team, the opportunity and the time that we need to fight the insurance company on this, because they've clearly got it wrong.
Right. As I mentioned, short break and a phone call on the other side of this break, and we'll probably get to an email as well as we continue the Disability Law Show. Hang in there.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
And welcome back to the Disability Law Show. Tamar is always reachable, 1-855-821-5900. Consultations won't cost you anything, so feel free to give her a call. Back it up with an email. How about that? help@disabilityrights.ca. And if you just go to disabilityrights.ca, you will find a radio station in your market that carries our show. We do it all the time. Tamar, James, myself, Savannah, we're all over it. Get some great phone calls on the show. Thank you so much in advance for calling in and providing content for this TV show. So with that said, Tamar, let's get to our phone call for the day. Listen up.
I received a letter from my employer saying that they were doing a mass restructuring. As a result, my position was eliminated. I was already off on long-term disability leave due to a cancer diagnosis. If I lose my job, will my benefits end too? I'm continuing treatment and I'm not ready to return.
Great call.
It is a great call because it really does highlight our two areas of expertise at our firm, which is employment law and disability law. So look, let me focus on the disability aspect of it, but you can really see, John, that the two are really, really connected. So for our viewers, the short answer to this is no. If you are terminated from your employment, it doesn't necessarily mean that your long-term disability benefits end when you've got an ongoing disability claim, just to keep it simple for our viewers. So if you're on claim, like this caller is, receiving diagnosis and a treatment for cancer, and obviously long-term disability benefits have been approved and paid, that is separate and apart from what's happening on the employment side as it relates to long-term disability benefits. But we use the word benefits loosely or generally. And so I do want to touch on the fact that if you lose your job and your employment status, and with that job you would have had group extended health plan, LTD rolls up under that plan, as does coverage for medication, drugs, treatment, therapies. And so unfortunately for this caller, that coverage is likely to end after a certain period of notice that she is likely entitled to under the law, under the Employment Standards Act. So again, let's not forget, long-term is meant to continue, but other benefits may end because those are tied to your employment. And so here's what's really, really difficult for an individual like this. What do you do in a situation like that? She referenced restructuring, referenced mass termination. That triggered my mind that there could be an employment avenue here that she should absolutely consider. Your job is not necessarily protected, John, if you're on a disability leave. Yeah. But it sort of is in the sense that it is a human rights violation potentially if she was targeted in this restructuring. Yeah. Absolutely. If the restructuring was just her and maybe the other guy who's off on disability, yeah, that's a problem. Yeah. That's an issue. So you do want to go down that path, but you also want to go down that path with a firm that can tell you how to prioritize those claims and how those two issues are going to work together. Because the other element of this is this. She's going to receive some element of severance. Most employees in Ontario have a protective amount. Across the country, there's legislation that protects certain minimum entitlements under the law. And so when you're thinking about, well, what money am I going to get and how is that potentially going to impact my long-term disability claim, this goes back to what I said at the start of the show. Get a copy of your policy. That section where it says CPP, that section will also potentially have a section in it that says if you get severance or termination pay, insurance company also gets a credit for that potentially. Now, it's got to be very clear in the policy for them to have that, but it's certainly an element of this as we start to analyze how best do we go forward with her situation, what do we do to support her if long-term disability is cut off, and most certainly let's get her an employment consultation and assess whether there's more entitlements there that she needs.
And that is all we got time for. Reach out to Tamar. That we're done. Again, 1-855-821-5900. Consultations are free and help@disabilityrights.ca. We'll catch you next time on the Disability Law Show. Thanks for watching.